Introduction to International Humanitarian Law and its application in the occupied Palestinian territory. Introduction. As conflicts and wars erupted throughout human history, humankind became aware of the need for shared principles and values to protect communities from suffering and loss of life caused by wars. International Humanitarian Law, or IHL, is one key development applicable in our modern-day life that came to exist as part of international law. IHL, in particular, aims at limiting the effect of armed conflicts on civilians and those who no longer participate in hostilities. IHL also intends to restrict means and methods used in wars and armed conflicts in order to minimize unnecessary suffering and destruction. It uses treaties and conventions to govern states' practices with one another and with citizens and businesses of other states. IHL is constituted mainly by the Hague Conventions, the 4 Geneva Conventions of 1949 and their additional protocols, and customary international law. IHL is applicable in cases of armed conflict and belligerent occupation. In 1967, Israel occupied the Palestinian territory, imposing effective control over the territory. Accordingly, IHL became the primary framework that governs the relations between Israel, the occupying power, and the Palestinians, the protected people residing in the occupied Palestinian territory, referred to as the OPT. The OPT encompasses the West Bank, including East Jerusalem, and Gaza Strip, all of which are considered occupied and to which IHL is applicable. Who does international humanitarian law protect? The 4 Geneva Conventions protect different categories of persons. The First Geneva Convention protects members of land forces or armies who get wounded or sick during hostilities on land. The protection covers medical and religious personnel accompanying armed forces. The Second Geneva Convention provides protection to members of armed forces who become sick or wounded and those who are shipwrecked during hostilities at sea. The Third Geneva Convention protects prisoners of war. It functions as a safeguard to protect them from inhumane treatment as combatants and ensures their rights are respected and fulfilled. The Fourth Geneva Convention is concerned with the protection of the civilian population in conflict areas. The 4 Geneva Conventions and their first additional protocol apply to cases of international armed conflicts. Common Article 3 and the second additional protocol apply in cases of armed conflicts that are not international in nature. The Fourth Geneva Convention of 1949 and its additional protocol of 1977, as well as the Hague Regulations of 1907, apply in cases of occupation. IHL also provides a set of fundamental principles for the protection of different categories of persons. The first principle is the principle of humanity, intended to humanize the conduct of war and restrict the means and methods used. The second principle is the principle of distinction, which means parties to a conflict must, at all times, distinguish in their conduct of hostilities between combatants and non-combatants and civilian objects and military objectives. The third is the principle of military necessity. This principle allows actions that are necessary to achieve a legitimate military goal, taking into account the restrictions imposed by other principles, which strike a balance between military goals and humanitarian necessities and considerations. The fourth is the principle of proportionality, meaning that parties to a conflict must refrain from launching attacks at legitimate military targets if the attack is expected to cause excessive losses, such as deaths and injuries of civilians, and damages to their properties. These principles are essential during the conduct of hostilities. In the context of belligerent occupation, the provisions are even more nuanced. In the context of occupation, the principle of military necessity cannot be argued for appropriating public immovable property, such as public lands and buildings. The occupying state must administer it according to the rules of usufruct. The occupying state shall be regarded only as administrator and usufructuary of public buildings, real estate, forests, and agricultural estates belonging to the hostile state and situated in the occupied country. It must safeguard the capital of these properties and administer them in accordance with the rules of usufruct. Article 55 of the Hague Regulation. How is IHL applied in the OPT? According to Article 42 of the Hague Conventions, a territory is considered occupied when it is actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. Article 43 of the Hague Regulations continues from the established de facto control of the territory, where the authority of the illegitimate power passes into the hands of the occupying power, placing administrative obligations on the invading army for the duration of time that the authority is established and can be exercised. Thus, a belligerent occupant does not acquire sovereignty over the territory and is considered a temporary administrator. Israel, as the occupying power, must administer the OPT in accordance with the rules of IHL and provide the necessary protection and basic needs to the occupied Palestinian population. The occupying power must only administer the territory and its immovable natural resources under the temporary rules of usufruct. It does not have sovereign rights over the occupied territory. The occupied Palestinian people are the inherent sovereign of the territory, and they have the right to freely determine their political status and freely pursue their economic, social, and cultural development, and to act in the best interests of their collective right to self-determination. In spite of the nature of the prolonged Israeli occupation of the OPT and the annexation of the territory, in part or as a whole, by Israeli occupying forces, which constitutes an unlawful act, the application of IHL is not ambiguous in its protective provisions towards the territory and the population, nor does it change the status on sovereignty. IHL highlights the obligation of parties to conflicts, such as the obligations of the occupying power towards the occupied territory and the obligation to protect the civilian population in the occupied territory, and the responsibilities and obligations of third states. Protection is established in other frameworks of international law, such as International Human Rights Law, or IHRL, which is applicable at all times, in peace and in conflict. IHRL bridges the gaps in IHL protection provisions and overlaps in restricting the behavior of occupying forces exercising power. Additional Protocol 1 of the Geneva Conventions of 1977 also applies to armed conflicts in which peoples are fighting against colonial domination and alien occupation, and against racist regimes in the exercise of their right to self-determination. This provision is established as part of customary international law. For the principles of equal rights and self-determination to be realized, there is a need to end colonialism and respect the expressed will of the people to live freely. This is particularly relevant to the OPT, in which the Israeli occupation and control of Palestinian land have been rejected and resisted throughout Palestinian history, even before the occupation in 1967. Notably, the Palestinian people have been colonized even before the creation of Israel in 1948, when the vast majority of Palestinians were displaced and expelled, both internally and to neighboring countries, and became refugees. Palestinian refugees are currently denied their right to return. How does Israel violate IHL? Israel, the occupying power, has violated many relevant provisions of the Hague and Geneva Conventions and has committed grave breaches of the Fourth Geneva Convention since the start of its occupation of the OPT in 1967. Land appropriation. After the occupation of the Palestinian territory, Israel has put in place a system of complex legal and bureaucratic mechanisms to systematically appropriate public and private land from the occupied Palestinian territory. Since the start of the occupation in 1967, Israel has appropriated large areas of land in the OPT. Israel has appropriated both public and private land for the benefit of Israeli settlers residing illegally in the OPT, for the construction of the annexation wall, and for the exploitation of Palestinian natural resources. The confiscation and destruction of private property is prohibited under Articles 52 and 53 of the Hague Regulations, and is only allowed under very specific circumstances for military needs by the belligerent occupant. Concerning public land, Article 55 of the Hague Regulations allows the belligerent occupant to only use public land through temporary usufructuary privileges to ensure that the protection and functional maintenance of the land of the occupied state remains intact for the returning sovereign. Additionally, Article 8 of the Rome Statute of the International Criminal Court establishes that the extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly constitutes a war crime. Settlements and population transfer. Through its settlement enterprise, Israel has violated Article 49 of the Fourth Geneva Convention, which prohibits the occupying power from transferring its own civilians into the occupied territory. Such a practice amounts to a war crime under the Rome Statute of the International Criminal Court. Israel, since the start of its occupation in the OPT, has created a coercive environment for the Palestinian occupied population, denying them most of their human rights through a system of discriminatory military orders, resulting in the displacement of thousands of Palestinians. Forcible transfer and displacement of the civilian population in the occupied territory are prohibited under Article 49 of the Fourth Geneva Convention and amount to war crimes. Collective punishment. The blockade of the Gaza Strip, reductions of fuel and energy supply in the Gaza Strip, and the construction of the annexation wall are examples of collective punishment practices used by Israel against the Palestinian people. These violations negatively impact the entire population in the OPT. Article 33 of the Fourth Geneva Convention states that no protected person may be punished for an offense he or she has not personally committed. Collective penalties and likewise all measures of intimidation or of terrorism are prohibited. House demolitions. Israel, the occupying power, demolishes houses of Palestinians under different pretexts, but mainly under the pretext of unlicensed construction. Tens of thousands of Palestinian homes have been demolished since 1967. The demolition of these houses is considered a destruction that is not justified by military necessity and is prohibited by Article 147 of the Convention. It also amounts to a war crime under the Rome Statute of the International Criminal Court. Many Palestinians have had their houses demolished after a family member had been accused of carrying out attacks against Israeli occupying forces or settlers. This practice is prohibited under Article 33 of the Convention as a form of collective punishment. Crime of pillage. Israel is forbidden, as the occupying power, from using state land and natural resources for purposes other than military needs or for the benefit of the local population. This applies to all natural resources in the OPT. In reality, lands are being confiscated for the benefit of the occupying state and its illegal settler colonial enterprise in the occupied territory. Such unlawful appropriation of property and exploitation of natural resources by Israel amounts to pillage, which is prohibited by both the Hague Regulations and Fourth Geneva Convention, and is a war crime under the Rome Statute of the International Criminal Court. Israel is violating its obligations as an occupying power in the OPT by encouraging and facilitating the exploitation of Palestinian natural resources for the benefit of the occupying state and its population. And it is actively allowing the pillaging of resources by private actors. For example, some companies are involved in exploiting materials of the Dead Sea and natural gas in the Mediterranean Sea off of Gaza's shores. Others are involved in extracting Palestinian stone through quarrying activities. Much of these activities are for the benefit of settlers. Criminal responsibility for the crime of pillage covers all those involved in the crime, including state officials or private actors such as businesses and corporations involved in the unlawful activity of pillage. Palestinian prisoners. Under the Fourth Geneva Convention, protected persons who are accused of offenses must be held in prisons within the occupied territory if convicted. They must be provided with health care and with food sufficient to keep them healthy. Most Palestinian prisoners are held in prisons within Israel away from their families, and family visits are restricted through Israel's arbitrary permit regime. Israel uses 18 prison facilities for Palestinians, all of which, except for one, are located inside Israel. This may amount to an act of forcible transfer, which is a deliberate violation of the Fourth Geneva Convention. Israel uses administrative detention as a policy. IHL imposes strict limitations on the use of administrative detention. Under Article 78 of the Fourth Geneva Convention, administrative detention is allowed for imperative reasons of security. Since the start of the occupation in 1967, thousands of Palestinians have been placed under this type of detention without charge or trial, and through the submission of secret evidence not available to imprisoned persons. Prisoners are held for months, and periods of detention can be renewed indefinitely. Concluding remark: International humanitarian law is a body of law introduced to provide protection to those who do not or those who no longer participate in hostilities. It regulates the conduct of hostilities and cases of military occupation. It also imposes obligations on the parties to a conflict and third state parties. Common Article 1 of the four Geneva Conventions obliges high contracting parties to respect and ensure respect for the conventions. If states fail in protecting and preserving international law, impunity prevails, allowing the continuation and expansion of illegal acts. In particular, impunity ensures that civilians pay the highest price.